apply to have a family member join you in the state? Well, that depends on the nature of your permission. There are certain types of permission that give you a strong entitlement to have family members join you, while others give you a more limited chance to do this. If you're an EU citizen who's exercising EU treaty rights in the state, then you're entitled to have your nuclear family members and your or your spouse's dependent parents join you. Provided you can show that you're exercising EU treaty rights and can prove the family relationship, permission should normally be granted. In the case of a dependent family member, the dependency also has to be shown. Other family members who are not members of your nuclear family may also be eligible to join you. To be eligible, it must be shown that in the country they are coming from, that they are your dependents or members of your household, or that there are serious health grounds that mean that they strictly require your personal care. Your non-marital partner may also be eligible, provided you can show that you're in a durable relationship. If you've been granted international protection, then you'll have a right under the International Protection Act 2015 to have your spouse and minor children join you in the state. However, your marriage has to be subsisting on the date that you applied for international protection. If it takes place after this time, then your spouse is not eligible to apply for family reunification under the 2015 Act. Instead, an application can only be made under the policy document on family reunification, which we'll talk about later in this video. If you're a minor who's been granted international protection, then your parents and minor siblings can join you in the state. Once you have international protection and any of the above relationships can be established, family reunification must be granted, unless certain circumstances arise. However, the application for family reunification must be made within 12 months of the issuing of your refugee or subsidiary protection declaration. All other applications to have family members join you in the state can only be made under the Minister's policy document on family reunification. As this is policy only and not based on the law, the Minister has a wide discretion when deciding on an application. However, in certain types of applications, along with considering the policy, the Minister must also consider certain legal rights. When considering these, there is no discretion, and if refusal would result in a breach of the rights, then the application must be granted. If you're an Irish citizen, you can apply for family reunification with your spouse or your de facto partner. You must be able to satisfy certain financial criteria in order to sponsor your family member. In particular, you must not have been mainly reliant on state benefits for a continuous period of in excess of 2 years and must have earned a certain amount over a 3-year period immediately before applying. If you're an Irish citizen applying for a de facto partner, you must be in a relationship akin to marriage, including living together, for 2 years before applying. Certain other types of permission allow you to apply for family reunification under the policy document. The permissions are divided into 3 categories: Category A, B and C. Category A can apply for immediate family reunification, while Category B can apply after 12 months. Category C is not eligible to apply. Critical skills employment holders are in Category A, while non-critical skills employment holders and Stamp 4 holders not covered under more favourable arrangements are in Category B. Strict financial thresholds have to be met in order to sponsor a family member. An application for an elderly dependent parent can also be made, but again there are strict financial thresholds that you must satisfy, and the application must be made when the family member is outside of Ireland. If you want to apply for non-nuclear family members, you must have 2 years permission if you're in Category A and 5 years permission if you're in Category B. For detailed legal advice and assistance in making an application for a family reunification, contact us at Young O'Reilly & Company Solicitors.